Hey guys, welcome to this video. My name is John Watts. I'm a consumer protection lawyer, and I just got off a virtual trial, and so that's why I'm wearing a tie. And it occurred to me that, a lot of times in my line of work where we're doing trials, understanding the rules of civil procedure, that is very, very important. And I thought I would share this website with you. And we're not going to go into the details of these rules, but kind of give you an overview of them. So first of all, what are the rules of civil procedure? Well, those are the rules that govern civil lawsuits, just like the rules of an NFL football game. That tells you how you do that. Now, if you're playing basketball, that's different. If you're playing college football, there's going to be some differences. So when we're talking about lawsuits and how you file a lawsuit, how you respond to a lawsuit, how you conduct discovery, what about summary judgment, all those types of things are covered by the rules of civil procedure. So every state has its own version of the rules of civil procedure. So where I practice, there's Alabama rules of civil procedure. And then if you're in Florida, there's Florida rules of civil procedure. Georgia and New York and all these places. And they can have different numbering systems, but the most common is to really basically track these federal rules. And so that's what we do in Alabama. And in most states, I think that's true. So you can look at these, and this is federalrulesofcivilprocedure.org. It's a pretty good website, right? And these are updated through December of 2019. So these are the 2020 rules. And they get updated once or twice a year, but these will be accurate enough for our purposes. And of course, if you're in state court, you need to find your own state version of the rules. And as I mentioned, they may or may not match the numbering, but probably they match the numbering. So I just want to show these to you. So we have this first section, which is the scope of the rules, the form of action. In other words, what do these rules do? And what is the form of action? So let me just click on this just as an example. There's one form of action, the civil action. Now, before these rules, there were all different types of things, sort of complicated names for, but civil lawsuits, we have a civil action, same thing. And then Title II is, okay, now that we know what a lawsuit is, how do we start one? And how do we serve the other side with that lawsuit? Well, this is what we do. So Rule 3 is a civil action is commenced by filing a complaint with the court. So that's how you start a lawsuit. And then this tells us about the summons, Rule 4.1, how do you serve people, Rule 5, serving papers, Rule 6, how do we compute time? So a lot of times in court, judge may say you have 10 days to do this, or 5 days to do this, or 28 days. Well, how do you count? And do you count weekends? Do you count holidays? What do you do? And what happens if your deadline falls on a weekend or a holiday? Do you take it back one day or do you go forward one day? Well, these rules tell us. And then we get into Title III, and this is a big area of focus when you're in court. And that is the pleadings and the motion. So what types of pleadings are allowed? What's this Rule 9, pleading special matters? And so let's just look at this real quick. And we've got, if we're pleading fraud, things like that, a party must state with particularity the circumstances constituting fraud. So it just tells us some little different rules based on what we're pleading. And then here's the form of the pleadings. Rule 11 is basically you can't say something that's false or untrue, or you can be sanctioned for that. Rule 12, this is a big one. These are defenses. So this gives us the deadline. This is going to be different in state court, but in federal court, it's 21 days after being served. And then we have, here are some defenses. And we've talked in other videos about affirmative defenses. So here are some defenses that can be pled, such as lack of subject matter jurisdiction, personal jurisdiction, improper venue. And then we have pleadings. And then we have what's called a motion for more definite statement. We have motion to strike. We have what happens if you don't plead certain defenses. Well, you would waive those defenses and lose those defenses. And then it goes on. And so we have Rule 13, counterclaim. What happens if you want to amend your answer or amend your complaint? Well, Rule 15 tells us about that. How do you amend or supplement your pleadings? And then Title 4 is party. So, can you sue more than one person at a time? Can you sue two people that have nothing to do with each other, that are totally different lawsuits? Can you bring them together? What about class actions? Then Title 5, this is a lot of sort of time is spent in this part of the world, and that is disclosures and discovery. So what are depositions? What are depositions when you do it verbally? How about depositions by written questions? That would be Rule 31. Rule 33, interrogatories. Rule 34, typically known as requests for production of documents. Rule 35, what if you want to examine a party? How do you do that? And let's just look at this. It's not used very often, but maybe there's a mental or physical condition is in controversy. So how do we get the ability to have a doctor examine somebody? Rule 36, request for admissions. Rule 37, what if somebody's not responding properly? How do you compel them to answer? Well, this tells us. Then Title 6 is all about trials. Title 7 is about judgments. So we have default judgments, Rule 55. Rule 56, summary judgment. That comes up a tremendous amount. And then we have some in Title 8, some other things. And so my point is just to let you see the big picture. And when people talk about rules, so they'll talk about, I'm filing a 12B6 motion. Well, what in the world is that? Well, we come back here to Rule 12, and we say, okay, here's A. That gives us the timing. And then we come to B. Okay, so how to present defenses. A party may assert the following defenses by motion. So when we're talking about affirmative defenses, those are put in your answer. But if you say, you know what, before I even file an answer, I want to attack this lawsuit. So you do a 12B motion. Could be 12B1. Hey, there's no subject matter jurisdiction. Judge, you don't have the power over this type of lawsuit. 12B2, lack of personal jurisdiction. Hey, as the defendant, you have no power over me because I'm not subject to this court's jurisdiction. That would be, for example, let's say I live in Alabama. I've never visited Wyoming. I've never done business in Wyoming. And I get sued in Wyoming. Say, there's no personal jurisdiction. That court has no power over me in Wyoming. Now, a national company, say a debt collector that collects all over the nation, a trucking company that drives all over the nation, we can sue them anywhere because we have personal jurisdiction over them. How about 12B3, improper venue? So somebody might say, look, you have subject matter jurisdiction and you have personal jurisdiction over me, but you sued me in the wrong place. This needs to go to a different court. That would be improper venue or insufficient service. And so the point is, whenever you see these things, you can look up the rule and read it. And of course, you need to look up, see what your particular judge or your particular district, if you're in federal court, how they interpret the rules. But typically, it's pretty uniform. And so if you have a particular interest in any of these rules, let me know. And I'll put those on the list to do a video. But I just wanted you to see, first of all, where you can find these. And again, it's federalrulesofcivilprocedure.org/FRCP. And that's the abbreviation for Federal Rules of Civil Procedure. So we say FRCP 56. Well, that's Rule 56 of the Federal Rules of Civil Procedure. And I'll drop this link also in a comment or the description. And I appreciate you watching, and I'll catch you in the next one. Okay, bye-bye.